Welcome
No,
to
ma'am,
Legal
you don't
Live
tell me
Wire.
to hold. No, ma'am, stop. Mute her.
Mr. Briggs, you're before the court today making first appearance, Raymond, on 2 charges. The first is malicious mischief in the 3rd degree. It's a gross misdemeanor subject to 364 days in jail and a $5,000 fine. Second is harassment, domestic violence. That's also a gross misdemeanor, subject to 364 days in jail and a $5,000 fine. Because the charges have domestic violence enhancements, they are something where if you're convicted of them, it would result in your inability to possess firearms. If
I
you were
don't own a
convicted.
firearm. That's what
Okay,
I told
again,
him.
I have to let everybody know whether you have guns or not. Because these are criminal charges, sir, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened today, sir, for a court-appointed attorney?
No, sir, I'll be getting mine.
Okay, sounds good. So enter a not guilty plea today.
Yes, I do have something I want to add, though. I was denied due
So if you
process.
have an attorney, or going to hire an attorney. Your attorney would probably have you exercise at this point your right to remain silent.
I don't
because
want to
you're on a-
exercise my right to remain
because you're on
silent
a
because I have
recorded
nothing
record.
to hide. So I was denied due process. I have paperwork that proves that I owned the car before I was married. So therefore the car is mine. And since we're in separation, no judge has divided property yet. So technically the car is still mine. So I wrote on my own car. That's a fact. Here's the paperwork. I
We're
sit
not
down
having
at the
a
bank.
trial today.
Well-
We're having your arraignment.
Okay,
You're entering a not guilty plea.
I was denied
You've
due
told me-
process,
hold on,
sir.
Hold on.
You said I could
You've told,
speak.
no, I
didn't want
didn't.
to
I said you should exercise your right to remain
I choose
silent.
not to,
You
sir.
told me that you're going to be hiring an attorney. Your attorney, if they were sitting there, would not have you making factual statements on the record.
That's my discretion, sir. Because I believe there's Fourth Amendment charges. I was denied all kinds of rights, and I will be coming back with a vengeance. I have
Are you
paperwork.
threatening the court?
I am
attorney?
not threatening the court anything. I'm not threatening anybody.
You just-
I have the
you
right
said
to
you were
sue.
coming
I have
back
the
with
right,
a
I have the
vengeance.
right to sue this city, and that's what I just said. So if you want to take that farther than that, that's up to you. I did not say that. I'm
You
making
said
it
you are
clear.
coming back with a vengeance.
With an attorney.
On
It
the
doesn't have
record,
anything to do with me. That's not a threat to you. The city. I said I'm suing the city. So you do what you want today. Go ahead and hold me in contempt. Go ahead. I'm suing the city. I will be suing the city. If you will take that as a threat, then that's fine. I will be talking to the city attorney. I've already talked to the city. I'm talking to people. I talked to the police chief already.
Yeah, I've seen how you've conducted yourself. so
Yeah,
far.
that's right. Because I'm being wronged. It's my house. She had no business being there. And she hasn't even lived there for 6 months. She hasn't paid a bill for 8 months. She can't just come there. I have rights.
You do?
Just because she's entitled to
So
be able
again,
to
we've-
be on the
again, we've
property
talked
doesn't mean
about-
she can just come.
We've discussed your rights today. We're not going to litigate your case today.
Do I
okay.
have the option to
This is-
speak with the city attorney
This
as
is a
well?
criminal court.
Do I have the option to speak with the city
Not once
attorney?
you say you're going to be hiring an attorney.
Do I have the option to speak with the city attorney? I'm not hiring an
Not
attorney.
today.
I want to speak with the city attorney.
Not today.
Okay, when would I be able to do that?
That's me, sir, and I will give you my card.
Okay,
But we do have some release conditions we will be requesting.
Okay. Go ahead, Ms. Carmen.
Yes, Your Honor. We are requesting a formal no contact order with victim notification.
it should have been me filing.
Oh,
She's
please, sir.
harassed me.
Please, sir,
All right, go ahead.
the facts of this case are highly concerning with regard to the threats that were made. These folks are in the midst of a dissolution. Statistically, through peer-reviewed literature, that is one of the highest risk times for partners who are splitting for domestic
Well, what about the time
violence.
I got punched in the chest 5 times? Nobody did anything about that, and I reported it to the officer. Upon arrest, I told him 2.5 months ago, I've been punched in the chest. I will take a lie detector test for that and pay for it. And I received
At this point,
nothing.
the city attorney is making her release recommendation. You need to let her finish.
I was denied due process. You guys didn't take my complaint. So you didn't even take my complaint. And then you don't want me to call it racism. You didn't even take my complaint.
The only thing we are doing today, sir, is you have entered a not
Well, there
guilty
should be
plea.
equal treatment under the law, and I have not
You're not
received it.
litigating your case today. I've already told you that. You've seen every other person come up here. I've entered not guilty pleas. I've set
What I
release
want to put this in
conditions.
the record is,
Sign
can I
it.
give this to the attorney so she can follow up on this? This is my proof that the car is mine. There's been no dissolution. No court has divided property.
So would you like me to continue?
Yeah.
So again, we are asking for the victim notification. There was an ex parte no contact order approved in Clark County Superior Court this week. However, as of yesterday, it had not been served, so there is not formally protection in place for the victim.
I don't go to her. I am at my house. She came to me. I never go to her. So why is the order
please-
against me when I
please
don't
let-
even deal with her?
Please let the city attorney finish her recommendation. So we're walking on a very fine line right here with your conduct in court today.
Okay, I'll stop. Sorry.
Thank you. Go ahead, Ms. Carmi.
So yes, Your Honor, and while there's no in-state prior history with domestic violence, there is a older mid-1990s arrest for assault 4. So there is some history there. We think all of the circumstances in this case, particularly with regard to statements of harm to the victim at this time, warrant that victim notification.
I don't even go to Oregon, sir.
I will
She lives in
add,
Oregon.
I will add, because Mr. Briggs has brought it up, we are not seeking to remove him from the home that he is residing in.
How you gonna, she don't even live there. Are you kidding me? She doesn't live there. I paid the mortgage there for the last for 4 years. I paid the mortgage, and I can prove that.
Mr. Briggs.
I'm trying, you're gonna remove me from my home? What are you
No,
talking
I'm
about?
just saying she is not.
Why are you even saying that?
Because,
She don't live there. Her address is in Oregon. Why are you even saying that?
Your Honor, the reason that I'm bringing this up is that the victim has requested a civil standby so that she can go get her personal belongings from the home.
Property has not been divided by the court. She has her personal items and her personal belongings. And then the court has to divide the property. That's what I've been waiting for. I've
We-
encouraged her to file the
I-
divorce papers, sir.
I will be finished here shortly, Your Honor. The proposed NCO that we have drafted, after contacting Battleground to make sure this is something that they could do,
That's against the law. No
is
way.
is that she can call for a civil standby where they would go to Mr. Briggs' home. She has the same 15
She
to
can't
20.
come there and just take whatever she want out of the home. It hasn't been divided by the divorce court. I don't have a problem sharing, but it's an argument every time.
So one of the things that you've brought up, Mr. Briggs, today is that there was likely separate property, it sounds like, prior to your matrimony.
Yes, sir.
My assumption, and I could be wrong, my assumption is that the other party also had separate property prior to the prior to the matrimony. So yes, you are right. The court, if the property is shared property, the court certainly cannot order a person to go in and take shared property. You are correct on that. The court, however, can, if there is separate property of hers in the residence, allow her to retrieve separate property.
But she's taken my property. That's the reason why I don't want her
I
in the
don't know what
house.
she's going to do. We're talking about prospectively, sir, not retroactively. When she shows up at your home and takes her separate property, that would be allowed. Do you understand?
That's actually not allowed because
Yes, it
I
is
still,
allowed.
no, it's not. No, it's not. No, it is not. She can't just come there and take stuff. Now, she
can
could
take
have
things
asked
that
for,
were separate property of hers.
she does have her
prior
property. The
to
only thing is,
divorce.
sir, she didn't even have any place to put the stuff. She's in a bedroom at her mom's. Now, she can have the kitchen table, which is hers. I don't have a problem with that. I've held nothing from her. I don't want to fight. The reason why we have not been around each other is because of what happened the other day. I didn't want that to happen. I've made many statements to family and relatives that I refuse to be around her. I believe she's demonically possessed by the Jezebel spirit. So I don't want her around me. There's a visceral reaction that I haven't felt around a person in many years. If I'm from here to her, I want to throw up. I literally cannot be around her. and I've required that she not come to the house. She came to the house because I refused to get the HELOC with her to help her pay off her bills. So she came to the house the next day, and then that's when everything started. I was sitting there with my brother-in-law, drinking beer by myself, like I always do. I didn't go to her. She came to my house. And she has forfeited, I haven't proved it, but she's forfeited her right to the property. She hasn't paid a single bill there in 8 months. And when she left, the moment that she took her and got a new bank account at Columbia Credit Union, that's the day of separation. That was over 8 months ago. She cannot just come to that property. She cannot.
So, Your Honor, I have, if you do adopt it, change the language in the civil standby to indicate that the law enforcement agency would assist the protected party in obtaining personal belongings.
She has her personal belongings, and not only that, she stole every picture off the wall, which she was not entitled to. She stole all of our financial records, which she was not entitled to all of it. So now I'm in a position when I do go to court to battle her, all the financial records are in her possession. Because she stole them out of the house. But when I got arrested, they wouldn't even let me go and secure my home or give them any instructions on what to do with the property. I said, don't let her in there. I got silver. She's going to steal it. And she went right in there and started taking everything off the wall. She left me 2 tablespoons and 4 teaspoons. She knows I love tablespoons. So everything she did was to spite me. I have gone out of my way to stay away from her. You can interview any one of my neighbors.
The court only establishes this court. This is a criminal court that you're in.
And that's
today.
what I'm saying. You don't have the right to
This is a
divide
criminal-
property in a
this
criminal
is-
court. We haven't gone to court yet. You don't have jurisdiction to divide property.
I have jurisdiction for a victim to be able to retrieve property.
What would I be
when a
keeping
no
from her, sir?
contact-
She has all of her clothing. There's a table and a side table in the bedroom. That's all that's there, and whatever's in the garage. I haven't kept her from anything. I'm trying not to kill her. She's come to me.
Okay, so, Your Honor.
Okay.
That's not,
I
now
would-
hold
I
on.
would actually ask he be held on $10,000 bail.
Listen,
Okay.
sir, listen.
You can't. say
I'm
the
not
word
saying it
sure.
like that. I'm saying that I've tried to keep her away because of violence. I don't
Very
want.
much keeping with statements. that
Oh
were
my
made
God,
at
do
the
you
scene.
understand? Does
I
anybody
Yeah.
understand?
Yeah, take
I
him into
didn't
custody.
never touch her.
Officers take him into custody.
I never touched her. I didn't want to harm her. That's what I've been doing the whole time. Man, I'm getting crunk down here and it's gonna be on. This is prejudice and
Okay, I'd like-
racist as hell.
I'd like no bail.
You're racist.
Well,
I have
he
not
just
done
threatened-
anything to her.
He just threatened to get crunk on the court.
So what? What is that? So you're taking away my freedom of speech? I can't express myself now?
Can't
I
threaten.
haven't committed any crime. I haven't touched anybody.
All right, so
I don't want her at the house. That's what I've tried to avoid.
at this stage, we're gonna set Mr.
Ain't never,
Briggs-
she punched me in the chest. I'm prosecuting her, so you take that. I want to see somebody about that right
we're gonna
now.
Set Mr. Briggs.
And I'm pressing charges on her.
Out 1 week.
She punched me 5 times and I will take a lie detector and pay for it.
We're gonna
Can I
set
speak to
Mr.
somebody
Briggs
and
over
press
to
charges
the
on her?
12th of December, twenty
You know
twenty-four
what I'm saying?
at
Hey, you know
8:30
what? My
a.m.
shoulder, I'm in,
We're giving you extra.
The release conditions in place are to violate no laws, appear at all mandatory court dates, notify the court of any change of address or phone number. I'm signing off on a standalone no contact
So
order.
I said I didn't want to kill her and I've never threatened to kill her. I'm just expressing to you that I don't want any bodily harm towards her. And you're arresting me for that. And it's a freedom of speech. I didn't touch her. I've never put a hand on her. She punched me. Can I press charges? Can I see someone to press charges on her right now? Your Honor? Your Honor?
This is your arraignment today, sir, on criminal charges. You've made a number of threats on a recorded
I
record.
didn't make any
I
threats
told
to
you-
anybody.
Well, we'll listen
How is
back.
that a threat? Freedom of speech. I didn't threaten anybody. I didn't say I want to kill her. I said I don't want to.
Sure, well, we'll listen to what they say on the record. You're being recorded. I told you to remain silent.
Well,
Your
hey,
choice.
I knew you was gonna do this. I knew you was gonna wait till I slipped and then you was gonna throw me in jail, and that's fine. because I'm coming with Trump. That's not a threat. That's my personal lawyer that I'm gonna get to fight you guys
When
with.
people threaten killing someone on the record, sir, I take
I
that
didn't threaten to
extremely
kill her.
seriously.
That was not a threat to kill her. I didn't say I'm going to kill
We're
her.
recording.
I said I don't want to, and
That's
that wasn't
fine.
even, that was just a figure of
It's,
speech.
it's recorded.
I
We're
don't
good.
care if it's recorded.
We're on intensive pretrial release. At this time, I'm gonna impose bail in the amount of $25,000.
And then, Your Honor, if it is posted, could we have the victim notification?
Victim
requirement?
notification will be put in place.
Thank you.
This is a railroad, man. I'm telling you.
All right, thank you, sir.
Oh, witness this, that's bullcrap. He came to my house. Jesus Christ is my Lord and Savior, you devils, you're all devils. Devils.
We'll call a couple other folks here up here in just a second. I'm gonna let whatever's going on back there resolve. Let me just figure out, I know some new folks have come into the courtroom, so I'm gonna call just a couple of names. If you hear your name, just raise your hand. Hopefully, we've had the most turbulent part of our docket is over with now. Please don't get any ideas, folks. Harold and